The moment we have all been waiting for is finally here. The hearing to dismiss, pursuant to anti-SLAPP, all allegations of defamation against Karen Read and Aidan Kearney are finally here. The motions that we have went over, save for one, are being heard by Judge Gildea. And today, in this very lengthy presentation, we are going to go over it. So sit back, relax, and enjoy the show. It doesn't say anything new. You must follow the law. He was present, so I think he can answer whether or not it happened or not.
Have you had any conversation with the prosecutor?
I could say the same thing by taking Amber Heard as a client.
Mentative, don't you think?
Oh, hardly.
Are you able to estimate of those 1,000 different types of cases dealing with accident reconstruction?
We're not with the jury present. That was a step.
Have you reached a verdict?
We, the jury, find the defendant not guilty.
Not guilty of
Not guilty.
Not guilty.
Not guilty.
Well, hello everybody, and welcome back to Buckle Up, It Is the Law. Folks, like I said, the day is finally here. We get to enjoy intellectual minds collide. Creative arguments are about to be thrown about. Creative ways of trying to insist that culpability and liability exist by Karen Read and Aidan Kearney. And you will see the gymnastics and the hoops that Chris Maddie is going to be trying to jump through this entire hearing. And then, of course, the responses from Attorney Pyle and Attorney Seligson, who just so swiftly and easily defend against any allegations by Christopher Maddie. I know this is a long one, but trust me when I say you do not want to miss the ending. Because two things happen. One, you're going to watch me get a visit from a friend who lives with us. I'm not going to spoil who it is. And secondly, you're going to see at the very end, without spoiling it, there is going to be a moment where you're going to go, Chris Maddie just said that? And it's almost all the way at the end. So you're going to have to watch and see how we get there. But that's my promise to you, that you do not want to miss this particular hearing under any circumstances. This is the hearing that will determine whether or not Karen Read and Aidan Kearney's defamation case against them will move forward or not. Now, obviously, the judge is not going to render a decision at the end of this video. He's going to take it under advisement. That is expected. But there is going to be a written ruling, and of course, we're going to cover that order on this channel in a few weeks when it comes down. But until then, enjoy the video. Let's get into it.
Good morning, Your Honor. Please. Good morning, everyone. Today is Tuesday, July 14th, 2026. This is the criminal court session at Plymouth Superior Court before the Honorable Justice Mark Gildea. Your Honor, the matter before the court is civil action 2683 CB 00541, Jennifer McCabe et al. Versus Karen Read et al. Counsel, if you could please state your name for the record and we start with the plaintiffs.
Good morning, Your Honor. Chris Maddie on behalf of the plaintiffs.
Good morning, Your Honor. Kieran Murphy on behalf of the plaintiffs.
And good morning, Your Honor. Jim Tuxbury also on behalf of the plaintiffs.
Good morning.
Good morning, Your Honor. Jeffrey Pyle on behalf of defendant Aidan Kearney.
Good morning, Your Honor. Adam Gardy, also for Mr. Kearney.
Good morning.
Good morning, Your Honor. Damon Seligson for defendant Karen Read.
Good morning. So we're here on motions to dismiss and pursuant to paragraph 8 of the Superior Court Standing Order 196 for in-person hearings where no person appears remotely, members of the public shall attend in person. Courtroom is open to the public. So the parties have all submitted extensive memos on the issue.
By the way, just real quick, it seems kind of odd that he has never begun a hearing like this about mentioning the fact that the hearing is open to the public. And it makes one wonder, why did he say that specifically? Was it just a random off-the-cuff comment? Or was it something more meaningful? Because remember, there's been a lot of issues in this case with respect to openness, transparency, directness, and he has been transparent about a few things, but he's been also keeping us in the dark on a lot of things, especially since July 1st, when I think he has lost all credibility, at least amongst the people. He now lurks in and is lumped in with the likes of Auntie Bev and Adam Lally, Hank Brennan, and all of those corrupt individuals. I mean, I wouldn't go so far as to lump him in with Proctor, of course, but a lot of people might, I imagine. So the fact that he leads with, oh, by the way, this courtroom is open to the public, anyone is welcome to participate, to me it seems like he is highlighting, because he knows the importance of this hearing. He knows that this hearing is a motion to dismiss pursuant to anti-SLAPP. Now, I do apologize. I promised you all that I was going to cover both Karen and Aidan's, and I did, and I was going to cover the responses to Karen and Aidan's, but we only got through Karen's. We never got to Aidan's, and the hearing is already here, so we are just going to proceed with the hearing itself. And I might do the motion later if you still want me to do it. Let me know in the comments below if you still want me to cover the motion. Otherwise, we will just continue moving forward.
Raised by these motions, I can't say at this point that I read every single transcript that was included with Attorney Sellickson's submission, but I have read and reviewed those that I believe to be necessary. And I have read all of the extensive briefing on the issues and the multiple affidavits, so please keep that in mind. I don't need a lot of background here. We all know the Duracraft framework.
Remember that Judge Gildea had to sift through almost 3,000 pages combined of all the motions, all the affidavits, the responses, and their exhibits. All combined are well over 2,600 pages, somewhere between 2,600 and 3,000. I don't know the exact number.
To which the SJC has returned. There's two steps. First, have the respective defendants shown that the claims against them are based solely on protected petitioning activities. To survive this first stage, the defendants each must show that the challenge count has no substantial basis in conduct other than or in addition to their alleged petitioning activity. If a defendant cannot make such requisite showing, their special motion to dismiss is denied. If the threshold showing is made, we go on to step 2, which is have the plaintiff shown that a defendant's exercise of the right to petition lacked any factual support or basis in law and has caused the plaintiff's injuries. Now, on the first step, I only need to conduct a facial review of the amended complaint to identify which factual allegations serve as a basis for a particular claim. I may need to look at other documents in the anti-SLAPP record to determine whether these allegations fall within the statutory definition of petitioning activity. That's an objective assessment to be made based upon the documents before me without resort to judicial fact-finding. I say the standard simply so the rest of you don't have to repeat it. We all know it, we don't have to repeat it. So let me start off with a few questions. Let me start with Mr. Kearney's attorneys. Who's going to, excuse me, let me start with the plaintiffs. Who's going to argue on behalf of the plaintiffs?
I am.
Okay, tell me this. Do the plaintiffs concede that Mr. Kearney's actions were reasonably likely to enlist public participation?
No, we do not.
Okay, so does everyone have their copy of the amended complaint?
Yes, Your Honor.
Anyone not have it? So let's look at...
Okay, so this is interesting. It feels like the judge is also a little torn. He was like, let's start with the defendants. Like, no, actually, let's start with the plaintiffs. Because he's like, I know what your motion is. I think the defendant's motion is, like both Karen Reed and Aidan Kearney's, are both very self-explanatory. We went over them. Like I said, both of them are on my channel. If you're not sure what's going on, go back and review those videos so that you can familiarize yourself with the arguments. Essentially, what you need to know, the TLDR, is there petition in activity, which is going to be the first question, and then the second question you heard what the judge had to say with respect to injury to the parties. So the first question to Chris Maddie, this is the guy who beat Alex Jones, and I put that in quotes because I think my grandmother can beat Alex Jones in court. We've already gone over that 100 times. But Chris got a very direct question from Judge Gildea. Can we just concede, or can you just concede, can we all just agree that Aidan Kearney was eliciting petitioning activity from the public when he was making his videos, etc.? That his ultimate goal was to get people to participate in the judicial process, meaning getting justice for Karen Reed, etc. And of course, as one might anticipate, Chris Maddie goes, no, absolutely not. Well, Christopher, The floor is about to be, probably, yours. Let's see what you have to say.
Paragraph 106. If anyone doesn't have it, the clerk has some copies.
See paragraph 106, Your Honor?
106, yeah. It appears, if you look at paragraph 106 and paragraph 126, and these are the allegations of the plaintiffs, it does appear you're conceding that his actions were likely to enlist public participation. So tell me how I'm misreading those paragraphs.
Your Honor,
So again, the judge is calling him out. It's in your amended complaint. A couple of paragraphs appear to be eliciting public participation. You seem to be conceding that. Now you're saying no. Which horse do you want to sit on? You can't sit on both. Pick one. That's Judge Gildea's challenge to Chris Maddie. Let's see Chris Maddie's response.
there are some defamatory statements and some conduct that he engaged in that we agree did enlist public participation in what we claim was a harassment campaign towards the plaintiffs, not participation in any matter or issue that was under review by a judicial body. But there was other conduct and other defamatory statements he made that we do not believe was likely to enlist public participation. And I can give you some examples of those. So for example, when Mr. Kearney confronted Ms. McCabe and her family at a youth lacrosse game, he did that on his own in the setting confined by a lacrosse game and shouted "cop killer" at her and in the vicinity. There was nothing about that conduct that was likely to enlist public participation in any legitimate petitioning activity.
Well, counter argument, Chris Maddie, and allow me to again repeat what he said in human language. Essentially, the defense to defamation is if you are enlisting public participation in the judicial process, that's SLAPP. You're just making somebody shut up for saying something that you don't like. You can't do that, okay? So if I can prove that actually I was saying all those things to make sure that the public is aware of your potential involvement in this, and I'm rallying the people to fight for justice, there is no problem. You lose on your defamation claim, which would mean Karen Reed and Aidan Kearney would win. Chris Maddie is coming up with this very specific example. Well, let's talk about just the lacrosse game when Aidan Kearney yells, cop killer," to Jen McCabe. The question is that particular instance defamation, or could that also be chalked up to, no, this was also him enlisting public participation in a judicial process by bringing awareness to the fact that Jennifer McCabe may have participated in the murder of John O'Keefe. Let's see what happens.
To the contrary, it was a verbal and physical confrontation at a lacrosse game directed towards Ms. McCabe. Voicemails that he left for Brian Allen and the McCabe family, which was essentially direct communication with them in which he defamed them directly. That type of conduct, although he later published it to an audience, that type of conduct is actionable on its own and not likely to enlist public participation. And so these are examples I give you, Judge, as to show that there is some conduct that Mr. Kearney engaged in that was not for a viewing audience, let's say, although he may have later published it to a viewing audience. And then some conduct that is actionable that was not likely to enlist public participation. I also want to just draw a distinction, Judge, if I may, between certain actions described by Mr. Kearney in his memorandum, which are not an issue in this case. So, for example, and I don't want to get too far afield from your question or get into general argument, but the idea that Mr. Kearney may have at times been involved in activities that were critical of the DA's office or critical of the state police or the Canton Police Department, that is separate conduct, not alleged by us to be actionable, than the conduct that we claim was illegal, which was a prolonged, persistent defamation and harassment campaign directed at the plaintiffs. And there's no question that he sought to enlist his audience in that same illegal conduct. But that's only step one of the analysis. That is whether somebody summons a mob or attempts to enlist them in some sort of participatory activity. That enlistment of public participation needs to be in furtherance of some petitioning activity.
Wait a minute. Hold on. I'm sorry. I think Chris is losing the plot here. He is legitimately arguing with a straight face that when Aidan Kearney was making his show and sharing his views on what the McCabe's, Alberts, and Higgy did, he was just summoning a mob and people, like, what is this, 1735? People going outside with pitchforks, showing up at Jennifer McCabe's house and labeling her a witch and burning her at the stake. Well, she probably would have been dead already if this was 300, whatever years ago, almost 300 years ago in that example I provided. But I'm not sure about this one, Chrissy. I understand what they're trying to kind of, you see, remember what Alan Jackson said yesterday. When you have the facts, you argue the facts. When you have the law, you argue the law. When you don't have the facts or the law, you attack the person. That's exactly, I think, the fallacy that Chris Matty is performing here. And that is he's attacking Turtleboy directly. And that doesn't make any sense. Not from a legal perspective. I think it's a very weak argument. I think it's a very ungrounded argument. I think they know. There's a part of me, like, listening to him speak, this is an attorney of a very high caliber. This is an attorney that doesn't need to work another day of his life. He is set for life. Now, granted, he's not a partner of Koskov, the firm he works for, but I don't think this man ever needs to work a day in his life, honestly. The amount of money that he was able to bring to his firm and the amount of money that he earned and continues to earn, I don't think this man needs to work, honestly. He just works because it's fun, because he enjoys it, he likes it, it keeps him busy, keeps his mind sharp. And he's been hired on this case, possibly for pro bono purposes. Maybe he wanted to undertake a challenge, he wanted to undertake a cause, said, hey, I'll do it for free. The most dangerous part, remember we covered, if you haven't seen the video where I talk about Chris Matty, you'll understand what I mean. He works pro bono a lot of the times. He does cases for free. He doesn't need to, like I said, he doesn't need to work for money. He has plenty of money. But it feels to me like might be just trying to ride the coattails of this trial to see if he can make another name for himself. And that's the danger of hiring a pro bono lawyer, McAlberts. If, on the off chance you're not paying him, I think that you made a horrible mistake hiring Matty, Tuxbury, and Kieran Murphy and all of those. Some of them are probably just taking your money, which, whatever, good for them. They're making a buck. But I'm afraid that I know how this is going to end. See, you have to understand it from the perspective of the McAlberts, okay? And I'll let me break it down for you. During the criminal trials, the McAlberts and Higgy were all like, this is going to vindicate us, right? The jury, they were praying the jury will convict. Karen will go to jail, then she'll be battling appeals, and they'll go, see, we told you! And that was going to be their plan, and that was going to be the end of it. Well, the first time it failed, but they're like, wait, it's a mistrial, we can do it again. So have the faith, keep the peace, keep the faith, let's try for number 2. And they went for number 2, and they failed again, and of course, they went and did that stupid interview where they looked guilty as sin, aged a ton, and it aged even more in the last hearing that we saw that they were present in a few weeks ago, where Colin was still there, not enlisted in the military. So we know, like, they give away the farm by showing up and being like, Colin's not in the military. Colin's in the military now! Like, really? Anyway, that's besides the point. So now they are helping the O'Keefes civilly prosecute. It's not a prosecution. It's not a criminal prosecution. I just call it a civil prosecution. You can just call it a civil action. It's the same thing. To civilly pursue liability from Karen Reed, against Karen Reed, for payment for the death of John O'Keefe. And then parallel to that, suing her for defamation as she sues them for all this sorts of things. And it just becomes one giant cluster. Well, filing the defamation case, if you are a McAlbert, you see, you have to put yourself in their mind. You have to put yourself in their shoes. Filing this action as a McAlbert is a win-win no matter what. Here's what I mean. let's say they win the defamation action on the off chance. They're like, see, we told you we didn't do it. And they can scream at that at the world. The judge found her liable. She defamed us. Now she's got to pay us money and blah, blah, blah. Probably not going to happen. It's a very, very tangential, weak claim as we're seeing it unfold. It's a very, very bad argument. But even if the McAlberts lose, they still win because, and this is their tactic, this is their plan, is to once again say, see, the courts simply cannot provide justice. The justice system in America is broken, folks. We fought in criminal court. We lost. The truth did not come out, right? The truth that Karen Reed killed him. We tried suing her for defamation. Once again, the courts have failed us. Oh, Lordy, the courts have failed us. And then once the O'Keeffes lose their wrongful death action, oh, Lordy, justice just cannot be found in the court system. Oh, dear Lord, what are we to do? That's their win, is they get to continuously argue the same pattern of the American justice system is broken. Nobody gets justice in America. If you want to get justice, you have to go somewhere else. That's their plan. Have you been injured in an accident? Have you been hurt by a doctor? Have you suffered from a dog bite? Have you lost a loved one due to someone else's negligence? Call us, 1-844-774-HURT. Get a trial lawyer to get you the most money you deserve.
And that's where, we would argue nothing he was doing was petitioning. It's not enough to say, oh, I can make false accusations against private citizens and provoke others to outrage. Yes, he did do that. But that's not what the petitioning test is. The petitioning test is whether that was done in service of any legitimate petitioning activity, which, as we say extensively and as I'll argue later today, was not what he was doing.
Let me ask a different question. Your opposition talks about Mr. Kearney acting on Ms. Reed's behalf rather than his own. And one possible reading of Cardinal, which everyone seems to cite here, could be that the anti-SLAPP statute protects those looking to advance causes in which they believe, and that the publications may be protected even if they're not intended to protect the writer's own rights.
Oh my gosh, that's beautiful. Isn't the case law supposed to simply protect the intent? It doesn't matter what the result is. But if the speaker or the writer's intent is to disseminate information, oh my God, we just got a clue into the insight of Judge Gildea's position. He, I believe, based on what I just heard, I mean, you can feel free to rewind and go back, because I am telling you, that was a dead giveaway as to what the judge thinks of this case so far. He is on Aidan's side, clearly, because he is reading the case law as if it's supporting Aidan. That's why he started with the plaintiffs. Oh my God, I just got it. Sorry, I just had an epiphany right here on camera. The reason he didn't start with Aidan's lawyers is because he's already on their side. He wants to hear, what is your counter argument? I'm already kind of reading Aidan's brief. I kind of believe this is probably correct. You're arguing this. Now I want to hear from you. He is asking the losing side to prove their position, and he just gave away the farm by saying that, well, maybe it's the framers of the anti-SLAPP law were focused on the intent of the writer, not necessarily the result that happens. Oh, wow.
So, if Cardinal does stand for that broad proposition, what do you say to Mr. Kearney's affidavit that essentially says he was advocating for a cause he believed?
So, a couple of things in response. And I'll address the Cardinal case more substantively later, it is clear that what Cardinal stands for is what I think is a fairly unremarkable proposition, that a citizen who has an independent interest in a cause can engage in petitioning activity in support of that cause and invoke anti-SLAPP protections. That, I think, is true. What we allege, and what Mr. Kearney seems to admit, is that this wasn't something he was doing independently on his own, that he wasn't seeking to engage in petitioning activity of his own, but in league with Ms. Reed and in part for a financial motive.
Oh, okay. All right, there it is. I was waiting for that. So he wasn't just fighting for a cause. He was doing it for the almighty dollar, Your Honor. But the case law already says that financial motive is irrelevant. So long as you have a just cause that you are petitioning for, that's petitioning activity. The case law is unequivocal that your monetary financial incentive is irrelevant. Again, Maddie's argument just seems to be very flat. I'm very unimpressed.
So the reason that we think Cardno is important, in addition to the fact that Cardno involved direct petitioning activity to governmental agencies, which we don't have here, is because it suggests that part of the analysis is if somebody is petitioning for a cause, whether they have an independent interest in promoting that cause versus whether what they are in fact trying to do is act in service of another's interests, which is what we believe he was doing. Obviously, he was self-interested from our perspective in gaining notoriety, celebrity, and profit. And so that's why we think Cardno's observation that the petitioners there had an independent, long-standing interest in this issue of the environmental consequences of the BP oil spill is different than what we have here.
So, who's speaking on behalf of Mr. Cardno?
I am, Your Honor.
So, if you believe that Cardno stands for that broad proposition, I mean, the plaintiffs point to Coburn and Fostello, I think, is another case they talk about. In the statutory language of 59H that restricts coverage to defendants who petition the government on their own behalf, correct?
Yes.
And they suggest that your reliance on Cardno is misplaced. So tell me, how are Mr. Kearney's actions similar to the Cardno activists?
From the very beginning of his blog posts, long before the Karen Reed case of killing John O'Keefe, Aidan Kearney exposed police corruption. He wrote stories about police who had basically miswritten police reports in order to protect the daughter of a judge, resulting in a major ethics investigation. He wrote articles about a state police officer who had misrepresented on her application that she had been following the laws, and in fact she had run a marijuana operation. His whole message and his whole sort of body of work has been to call out police corruption and misuse of state power. This was part of that. From the very beginning, he alleged that Trooper Proctor's investigation of this case was corrupt.
Well, let's go back to Cardno, though.
Sure.
Cardno, those activists had a personal stake in it, right?
No, the activist, only one of the activists even lived in Louisiana. The other did not. They did not have a personal stake in the outcome, and the SJC's decision did not turn on whether they had a personal stake in the outcome. The SJC's decision broadly says, and clarifies Fostello in case of anybody trying to overread it, that people who petition on their own as citizens about issues that they care about are protected by the anti-SLAPP statute. That is what the petitioners in Cardno did. They wrote an article about the Deepwater Horizon pollution scandal in the context of a pending judicial case in order to, and these are the SJC's words, increase the amount and tenor of coverage about that issue in the public sphere. That is what Aidan Kearney did here. He is fully protected by the Cardno case. Fostello and Coburn have to do with people who are under contractual obligations that made it such that they couldn't be deemed to be petitioning on their own behalf. Coburn involved a person who was retained as an expert for the government. And Coburn turns on the fact that you can't be petitioning on your own behalf if you're working for the government and you're sued for your work on behalf of the government. The Fostello case involves a reporter who was contractually obligated with her employer to write objective news articles about public hearings in the North End and was not putting forth her own opinion or speaking out on her own as a citizen about the issues in the North End, at least not for the issues that she was sued about. Aidan Kearney has clearly been speaking out on his own about corruption for a long time, and this was part of that body of work. He is clearly protected by the Cardinal case.
And do you want to briefly respond?
Yes, I would, Your Honor.
So, again, we already have gone over this, you guys already know, but essentially, Aidan Kearney's lawyers continue to argue that Cardno, the case where EPA folks argued and called out the government and later got sued for defamation and won, is exactly the same as Aidan's situation here. So it's a very tough hurdle for Chris Matty, and I see he's trying to do like some legal gymnastics and jumping through hoops, and I get it. I mean, when that's all you have, that's all you have. When you have a weak claim, when you have bad clients, when you have bad facts, you can't fix that. You have to argue what you have, and that's why in court there are winners and there are losers. You can never have everybody win. That's why a lot of courts advocate and they love mediation, because everybody walks away feeling a little bit uncomfortable. You know, let's say I sue you for $1 million because you are not subscribed to my YouTube channel. And I could say, well, look, I want a payment of $1 million, or in the alternative, just hit that subscribe button. In which case, you hit the subscribe button, you don't owe me $1 million. Great. Everybody wins, right? Simple transaction. Well, let's say you're like, I don't want to hit the subscribe button, Mr. Forman. My mouse is all the way over there, or the remote is on the kitchen table. I don't want to go grab it. And I also don't want to pay you $1 million. So what are you going to do about it? Well, I'm going to go to court and file a lawsuit for $1 million unless you hit that subscribe button. And the judge will send us to mediation, and he'll say, look, all right, how about instead of subscribing, you'll just leave a comment or a like on a video? And you'll say, okay, well, that's a fair compromise, I suppose. I don't have to be subscribed and be bombarded with amazing content every day that I absolutely would want to watch, but I am not going to watch because meh. And I'll say, okay, how about if you're not going to do that, I will agree to just take $250,000 because that is a more fair punishment for not subscribing to my channel. And you'll say, okay, fine. I'll just pay $250,000 and comment instead of being subscribed. That's a mediation, right? So everybody's walking away a little unhappy. I don't get my $1 million because that's what one subscriber is worth to me. You guys are all $1 million. That's the analogy that I'm trying to make. You all are $1 million to me. And I personally am okay walking away with $250,000 because yeah, it's not $1 million, but it's better than nothing. And you are not happy because, well, although I'm not subscribed like I wanted, I still have to comment and like his videos, that bloody bastards. So you're also a little uncomfortable, but we all are walking away feeling a bit uneasy. That's what mediations do. They kind of take the winner and the loser, like the 100 and 0, and they kind of break it in half, and they go 50-50. So this is what happens. This is what happens when you have a bad argument. Sometimes you're going to have to concede stuff. Now, I don't think Aidan or Karen are going to be willing to settle for any amount of money because that includes admitting liability. I think this one will be fought all the way to the bitter end. So this is one of those rare occasions where you are going to have a clear winner and a clear loser months and months and months down the road after all the appeals are exhausted. Because let me tell you, folks, at the end of the day, no matter what happens, no matter who wins, no matter who loses, the loser is going to appeal, guaranteed. And I'm talking about the motion to dismiss. I'm not even talking about the case itself. The case discovery has been frozen ever since the indication was made in early June, about a month and a half ago, 6-7 weeks ago, that Aidan and Karen both intend on filing anti-SLAPP motions. Discovery has been frozen, timed out. That means no interrogatories, no request for production of documents, no request for admissions, no depositions. Nothing is permitted by law. Do you understand how severe and serious a motion for anti-SLAPP is? And pending an order, it is still all frozen. And if and when, it's not an if, it's actually a when, Judge Gildea finally rules on this, there is going to be a clear winner and a clear loser. Your motion is granted or your motion is denied, right? Your motion to dismiss is granted, then Chris Matty will appeal. Your motion is denied, well then Karen Reed and Aidan Kearney will appeal. And discovery will remain frozen through the appellate process. So no matter what, like I said in a couple of videos ago at least, brace yourselves for the long haul, folks. This is going to be a at least 18-month ordeal from the date of the filing, which was what? April 16th, I believe? April 18th, something like that, 2026. We'll have some sort of potentially a resolution next fall or possibly next winter in 2027. And then it can still go to the Massachusetts Supreme Court, in which case we're looking at 2028 at the earliest. Unfortunately, that's just the way it works. So the gears of the justice system grind extremely slow. They grind slow in criminal cases, and they grind even slower in civil cases, as you can clearly tell.
Things. First, we allege that Mr. Kearney was essentially in a business relationship with Ms. Reed, in that she was providing him, directly providing him, material that he was then using to defame the plaintiffs. That's number one. So they were working directly together. This was not Mr. Kearney acting on his own on an independent mission.
But why does it matter? If the petitioning activity is petitioning activity, so what? So they were conspiring to get the truth out there together? How is that defamation? That's not defamation. That's journalism.
This was Mr. Kearney and Ms. Reed, as we've alleged, in a conspiracy to defame the plaintiffs. Number two, what we think is crucial about Cardinal's finding is that the court commented that the petitioners in that case were involved in an effort to directly petition the government. Yes, the conduct at issue involved 4 paragraphs in a magazine article, but they had previously directly engaged with federal agencies responsible for environmental protection and the like. What Mr. Kearney is now trying to do is convert whatever history he may have had, in his words, of exposing corruption or going after the police, and making that what he was doing here, when what he is alleged to have done here is not criticize the DA's office or criticize the police department, but very directly accuse private citizens of murder. And so that is, I think, never having petitioned the government directly as the activists did in Cardinal. So we see Cardinal as standing for the important proposition here that anti-SLAPP protected activity has to be tethered in some way to an effort to directly seek redress from the government or indirectly seek redress from the government.
But he was indirectly seeking redress from the government by bringing attention to this matter. You just made his argument for him. Am I missing something here? Or is Chris Matty showing up to court drunk? I'm serious. Not literally. I mean, just drunk and not making sense. And making Kearney's arguments for him. I don't understand what's going on here.
Here, Mr. Kearney has not argued in any way that his false accusations against our clients, that they had committed murder, was a message that he conveyed to the government, that he intended to be conveyed to the government, that he had any mechanism for reporting to the government, and on the one occasion...
But you just admitted that it can be indirectly relayed to the government by virtue of your simple petitioning activity. The broadcasting. Oh. It's like the most professional act of gaslighting I've ever seen in an open courtroom. The greatest trick the devil has ever pulled is to convince the world that he doesn't exist. To quote Kaby Lame,
given an opportunity to directly petition the government on the issues, he declined by invoking his rights under the Fifth Amendment because he believed, rightly so, that responding to inquiries in connection with any sort of petition would expose himself to criminal culpability. So that's why we think Cardinal is important here.
So is the relevance of his invocation of the Fifth that he did not avail himself of the opportunity?
Correct. I think one of the things that the court is going to be asked to consider is whether there are objective indicia, and this is from Blakesley, objective indicia of the plaintiff's intent to reach a governmental body in his petitioning activity. And one fact that I think is important here is that of all the activity he engaged in, all of which was, in our view, non-petitioning and not intended to reach the government, not designed to reach the government, when he had an opportunity to petition the government, he declined to do so. And we think that's an important objective indication that his intent was not to reach the government. In fact,
but maybe it's because he knew that that request would fall on deaf ears because they were all corrupt. So why on earth would he go directly to the government, the same people who are already corrupt, to be like, hey, listen, I know you guys really butchered this case intentionally to frame an innocent woman, but can you maybe stop? Okay, thanks. That's what he's asking. That's really what Chris Matty is saying. Turtleboy should have done that. Then they would have proven that he's not trying to defame my clients, the McAlberts and Higgy. But instead, he didn't do that. He didn't go to the corrupt individuals and tell them, stop being corrupt. That's ridiculous. That is a ridiculous argument.
his intent was to attack and defame private citizens.
Because that's all he had. Not to attack, but to call them out. Big difference. You call it attack and harass. I call it expose truth and seek justice.
So, Attorney Brown, what do you say to the relevance of the Fifth Amendment?
There is no relevance to the invocation of the Fifth Amendment because he's being sued for his statements that he made well outside of the courtroom. Those statements were petitioning. The suggestion that Mr. Kearney did not intend for his message about Karen Reed's innocence and the plaintiff's guilt to reach the government is belied once again by the allegations of the amended complaint. They admit that Mr. Kearney was responsible for the hundreds of people who showed up at the Dedham courthouse every day during that trial to protest. Who were they protesting? They were protesting the prosecution of Karen Reed. Who was prosecuting Karen Reed? The government. Mr. Kearney is clearly the leader of the national Free Karen Reed movement. And what do the words Free Karen Reed mean? What do they signify other than a demand, a petition, that the government do something or stop doing something?
Exactly what I said.
That's what he did. Obviously, his words reached the government. You have in the record, early on, in some of his Canton cover-up stories, a directive to his readers. Email Michael Morrissey at mmorrissey@state.ma.us. That's in one of the very first Canton cover-up articles. He says repeatedly that our presence protesting and doing standouts is intended to let the government know that we are watching and that we will not let an innocent person be railroaded. The anti-SLAPP statute doesn't extend just to speaking in court or petitioning the government directly, as in filing a police report. It extends, and I know Your Honor knows this, to statements that are reasonably likely to enlist public participation in an ongoing judicial case. I would submit that Aidan Kearney successfully enlisted the greatest degree of public participation in a judicial proceeding in the history of this Commonwealth.
Oh, that's a bold statement. And notice how he is confident, he is calm, he is direct, and most beautiful part is he is short and sweet. Keep it simple, stupid. Why? Because his argument is simple, not stupid. It's very simple, direct, and poignant. Just absolutely beautiful. And usually when you are right, you don't have to stand up there for very long to try and argue why you are right. You're just right. Bam, bam, and get out.
So let's talk about whether Mr. Kearney was doing it on his own behalf or for his reading.
Yes.
Plaintiffs suggest that the claims against him, can't show the claims against him are based solely on petitioning activity. And they point to Judge Krupp's finding of an intent to influence and pressure the witnesses, as well as to Judge Doolin's finding that Mr. Kearney's purpose was to interfere, obstruct, and a few other words in there. So what do you say to that?
Those rulings are not helpful on this motion in the court's task because they turn, as you just mentioned, on the question of intent. And the anti-SLAPP law provides that the motive behind protected petitioning activity is not to be considered at the first stage of the analysis, which is where we are. That's been the law ever since the Office 1 versus Lopez case, if not before, back in 2001. And the witness intimidation charges relate to conduct that is only partly part of this case. The witness intimidation rulings by those two judges do not analyze whether Aidan Kearney's statements meet the statutory definition of petitioning under the anti-SLAPP statute. Instead, all those decisions say is that there's probable cause to believe that he may have, on the right proof, committed certain crimes that turn on subjective intent, and that is not helpful in the current motion. The current motion looks at statements. The question is whether the statements for which he has been sued meet the statutory definition of petitioning under the anti-SLAPP statute, and the question of motive is not to be considered. And that, not to get off the topic of Your Honor's question, but the commercial motive that...
We'll get to that.
Okay.
Yep.
So, Attorney Manning, we're looking at the top of the line, Judge Doolin and Judge Krause. Statements are relevant.
So, Your Honor, Judge Doolin and Judge Krupp's findings that Mr. Kearney's activity was outside the protection of the First Amendment because it was activity that was intended to intimidate witnesses and harass witnesses is important because it provides you with some...
By the way, defamation has nothing to do with harassment or intimidation. Defamation lives in a bubble. You want to talk about harassment and intimidation? Go get a prosecutor to prosecute this. Or, you can sue civilly for the damage that you have incurred as a result of harassment and intimidation. But don't sue for defamation. Those are two different things. And yes, I know they've also included, kind of tangentially, the harassment and intimidation charges in a way, I suppose. But that's not good law. That's not a good argument. It's just, he keeps flailing. It keeps falling short of being anything of value. Let's keep watching. Don't forget to like this video, obviously, comment below it, and subscribe if you have not already.
Some insight as to how other judicial officers considered whether or not that type of conduct was constitutionally protected and therefore likely to be petitioned. In fact, what Mr. Kearney has done and what Ms. Reed has done by conspiring with him is pursued an unlawful campaign of harassment and intimidation and a tool that...
If I could have a nickel every time I heard the words conspired on an unlawful campaign of harassment and intimidation, I think I would be a millionaire by now.
In connection with that campaign was defamation. And so this, I think, the findings of Judge Krupp and Judge Doolin really just point to a truism. And that truism is, in the history of the United States, there has never been a case that we can find in which the court ruled that one citizen may publicly accuse another of murder outside of any reporting to government and be immune from civil liability for it. There's no case, Mr. Pyle has not cited any case. It would be a radical expansion of anti-SLAPP protections for this court to find that. And that is highlighted by Judge Doolin's and Judge Krupp's conclusions that what Mr. Kearney was doing with respect to these witnesses, and again, I think it's important to separate what we've alleged in the complaint, which has to do with conduct directed towards these witnesses, versus other conduct he may have been involved in, relating to the DA or the investigation or whatever it may have been. What we've alleged is a course of conduct directed at these witnesses. What Judge Krupp and Judge Doolin analyzed was the conduct he directed at these witnesses, and they found that there was no constitutional protection for it, which is exactly what we are saying in this case, that there was no constitutional protection for his defamatory and harassing conduct. The defamation here being in service of an effort not to petition the government, but an effort to intimidate and browbeat these witnesses into changing their testimony. And we make a specific allegation in the complaint in that regard, where Mr. Kearney says, this will all stop if you flip. He's not petitioning the government to get these witnesses to flip. He's petitioning the witnesses themselves, and he's encouraging others to intimidate them in order to create that outcome for Ms. Reed.
Wait, what? He's intimidating these witnesses in order to create the desired outcome for Ms. Reed? Well, he has a desired outcome for Ms. Reed, but he's not intimidating them. That's your argument, that he's intimidating them. But it's not true. It's not true, and you know it. Oh, Chrissy, how far you have fallen. Beating a conspiracy theorist like Alex Jones was easy compared to this. This is going to be a lot harder, and I think Chris is finally starting to realize this. But again, the arguments, I will give him, the arguments are very creative. They are certainly not something you would normally find. They do require legal finesse, legal gymnastics, and jumping through a lot of hoops to try and make sense of it all. But notice how long he's standing up there, arguing his point. You know, this reminds me of Cretan Waters. Earlier this year, about 5 months ago, on this channel, we covered Dick Harpootlian appellate brief and Cretan Waters' appellee response and the hearing that they did before the Supreme Court of South Carolina. It was this very, very similar fashion that Dick's argument was very straightforward, very easy to understand, very logical, very simple. You're like, yep, that makes sense. I get that. I agree. Interesting, yeah. And then Cretan had to he just kept grappling like, no, you don't need to. Here's why. And and you could tell that he's just like, he doesn't believe his own arguments and it's hard to make sense of it. A very similar thing is unfolding before us here today. We see Aidan Kearney's attorney, Mr. Pyle, just sharp as a tack, easy, boom, bing, bang, boom, we got this. And then Chris Maddie is just like, well, Your Honor, you have to look at it in context, and you have to look at it here, and if you look at it this way, and you have to understand also this, and at the same time, make sure that you don't forget that, and when you take it together, and when you take Karen Reed and Aidan together, and it's like, all right, I think I know who's winning here.
So, Attorney Pyle, along that issue, it would appear that your position is that the anti-SLAPP statute and the cases interpreting it preclude someone who has been publicly accused of murder by Mr. Kearney from prosecuting an action such as this.
I'm sorry, Your Honor, I don't understand the question. Preclude?
Well, put another way, how can publicly accusing someone of murder be petitioning activity?
Oh, easily. It depends on the context in which the statement is made. And I will have to say regretfully that the plaintiffs have broadly overstated the law about this. They say on page 20 of their brief that the law is clear that accusation of criminal conduct is only petitioning if made to the police or other law enforcement agency. That's on page 20 of their brief. There has literally never been a Massachusetts case that has said that. They cite 4 cases in support of that assertion, but none of them say that. And, of course, reports to the police are petitioning, but that doesn't mean that reports that, a statement that the police are investigating the wrong person, who the police should be investigating, are these plaintiffs, Brian Albert, Brian Higgins, Jennifer McCabe, Colin Albert. They should be investigating them. And the fact that they didn't even consider investigating them shows that this police department is corrupt. That's been Aidan Kearney's thesis throughout this entire time.
Yeah.
In a footnote in their brief, I note that the plaintiffs concede that generally raising awareness about police corruption is and can be protected petitioning activity, they say, but they draw this distinction. Accusing people of murder can't be petitioning. In this case, they are all part of the same ball of wax, because the reason that Aidan Kearney believed that Trooper Proctor and the other investigators were corrupt was because they didn't even consider investigating the people at 34 Fairview on that night in question. Instead, they decided to protect, he said, a Boston police officer and other powerful people in Canton. The corruption is bound up inextricably with the allegation that plaintiffs were responsible for this murder and not Karen Reed. The North American Exposition Company case says that in deciding whether statements are petitioning, you must look at them in a context in which they were made. The context is extremely important.
And by the way, folks, that little glitching is in the original. I do apologize. I know you're probably, I don't know if you're like me. I get a little frustrated when I hear those, you know, but unfortunately they were in the original. So there's nothing that I can do about it. It is not my video that is doing that. It is the original rendered video that we are reviewing. So I do apologize for the little glitches, but I don't have control over them, unfortunately.
And to say in the abstract that it can never be petitioning to accuse somebody of murder ignores that line of cases. You must look at the context in which this all occurred. The pending judicial proceeding against Karen Reed, Mr. Kearney's campaign to try to ensure that those charges would be dropped and that the plaintiffs would be charged instead. That is the context in which these statements were made. That is a context that contributes substantially to the finding that this was all petitioning.
Well, let's talk about context for a second, because many of Mr. Kearney's actions could be interpreted as seeking to make the plaintiff's lives miserable. In fact, he says something where he said it somewhere, I forget where I read it, that they'll never live a normal life. The plaintiff cites Judge Salinger's decision in Clay Court versus Colton for the proposition that targeting private plaintiffs for punishment is not petitioning activity. What's your response to that?
The motive behind petitioning activity, once you establish that it constitutes petitioning activity, is irrelevant. And I would suggest, Your Honor, that it's helpful to look at these allegations on a count-by-count basis. That is what Bristol Asphalt instructs must be done. The defamation count.
You all did that in your submission.
Well, I would respectfully say we did it better than they did. But on the defamation count, Your Honor mentioned earlier that reviewing the complaint is the first step in deciding what a claim is based on. That entire claim is set up at paragraph 156. In repeatedly publishing false statements asserting or reasonably understood to be asserting that the plaintiffs were responsible for the murder of O'Keefe and a cover-up of their purported role in the murder, Kearney published numerous defamatory statements. That is and then they list the harm and the fault and all sorts of other things that they say provide the foundation of the defamation claim. Absent from that is any allegation that he set out to make their lives miserable. Absent from that is any motive allegation, which isn't relevant in the anti-SLAPP context anyway. The statements that plaintiffs were responsible for the murder were part and parcel of his petitioning about the corruption of the case and everything else. That is what the defamation count is based on.
So, again, it all comes back to the exact same point, that Aidan did not simply say these words in a vacuum, simply with the intent to harm. Then that would be defamation, point blank. Let's say he would start going around and calling Higgins a pedo, right? He would start chanting, Higgins is a pedo, Higgins is a pedo. And he has no evidence of that. He's not trying to elicit any petitioning activity. He's not trying to get a prosecution of Higgins for that because he knows Higgins is not a pedo. But he would just go around saying it anyway because he felt like it, because he just wanted to, because it made him feel good, because it was destroying Higgins' reputation. That would be classic defamation. You are making a false statement about someone else that you know is false, or you're reckless with respect to its truth, and you're just going around saying it because, well, you want to ruin someone's reputation. That's defamation. That is literally the definition of defamation, and Aidan would be guilty of that. Remember 4 years ago, there was a YouTuber by the name of Tasha K. She used to go on YouTube and repeatedly allege that Cardi B was a prostitute and that she contracted some venereal disease from somebody. And I think there was also something about drug use. I don't remember. But I remember the VD, the STD, STI, whatever you want to call it, whatever the politically correct term is in 2026 for sexually transmitted diseases. She kept saying Cardi B has them. Well, she had no basis to say it. She had no logic or facts or reason or information. She just made it up, and she knew that it was going to generate hype, money, and people are going to watch her channel more because, wow, she's got inside information that clearly no one else has. Well, guess what? Turns out it was all a fraud, a sham. There was no facts. She had no evidence to back up any of her claims. As a matter of fact, Cardi B sued her for defamation. And you know what happened? Cardi B won. And she won nearly $4 million. And she won a nearly $4 million judgment against Tasha K and her YouTube channel. And even more recently, and a much higher figure, just a couple of months ago, a YouTuber by the name of Ryan Upchurch, in a very Alex Jones fashion, denying the Sandy Hook massacre. Ryan Upchurch, who is a Nashville-based YouTuber, apparently was hit with a nearly $18 million defamation judgment against him because he kept arguing that the family of the late Keely or Kylie Rodney did not disappear, and that the family was raising money for a child that based on a narrative that didn't exist. Basically, that they were scamming people into donating to their GoFundMe campaign, and it was all a sham. Well, guess what? Turns out it was right. And Ryan did not have any evidence to back it up. He openly and unapologetically defamed the Rodney family. So those are instances of defamation. My example, Cardi B, Ryan Upchurch. What Aidan did is not defamation. What Karen Reed did is not defamation. Notice the judge hasn't even touched the Karen Reed argument yet, and we are about over an hour into this video already. Not only that, but Karen Reed's role in all of this, I think, is so tangential. Her claim is the easiest to win for defamation, I think, because other than like her statements on Date Night or Dateline, whatever it was, and Rotten Mango, she hasn't really participated, quote unquote, other than allegedly feeding information to Aidan, which again is going to be very hard to prove. Because Aidan could have obtained that information through other, third parties, other sources. This whole thing is just so... Well, I already said it. To the McAlberts and Hagee, it doesn't matter. If they win, they win. If they lose, they still win because they get to argue the justice system is so flawed in the United States that they can't get justice anywhere they go. Well, that's because you're liars. And it's hard when you've committed crimes and you're lying about it and you're covering it up to be like, oh, woe is me. Why can't justice work? I love this hearing. This hearing is so awesome. Let's keep watching. Have you been injured in an accident? Have you been hurt by a doctor? Have you suffered from a dog bite? Have you lost a loved one due to someone else's negligence? Call us, 1-844-774-HURT. Get a trial lawyer to get you the most money you deserve.
And, we say all the counts are based solely on petition. But plainly, we state right there in paragraph 156 that that's the foundation of the defamation complaint. So anything else about notions of motives to make their lives miserable or that kind of conduct is irrelevant to that defamation, which is the central count in this case.
I do. I have several responses, if that's all right, Your Honor, in response to what Attorney Pyle was saying earlier. You asked him earlier, why would accusing a private citizen of murder be petitioning activity? And he said, oh, easily. And then he didn't cite a single case in which that has ever been found. That accusations against another citizen, not funneled to the government, not a police report, not a tip to the FBI, not using an intermediary to inform law enforcement that somebody has committed a crime, just speaking it, that another citizen has committed murder falsely, as you have to presume in construing our complaint. He says easily that's petitioning activity, and yet nowhere in the history of the Republic, as far as we can tell, has any court ever concluded that. In fact, to the contrary, we cite cases where, as Attorney Pyle says, petitioning activity is found where citizens report criminal conduct to law enforcement. But in those same cases, and I would urge you to consider Bowman, which is a First Circuit Court of Appeals case, those same cases acknowledge that the reporting of criminal activity to law enforcement is petitioning activity, but then reporting of it to third parties is not. And in that case, the plaintiff was somebody who had been accused of sexual assault. The accuser had previously made a complaint to the FBI and another governmental agency. Subsequently, she informed people with whom that individual was doing business of the same complaints. And the First Circuit concluded that while the earlier reports to law enforcement may have been petitioning activity, the reports to third parties were not. And here's the kicker. The reports to the third parties were to staff of congressmen. And even there, the First Circuit held that that was not petitioning. And there are other cases that we cite
But that was just simply the leaking of information from a police report after the police had begun an investigation into an alleged crime. That is a horrible analogy, Chris, and you know it. But again, that's all you have. I get it, so you have to make it. But that's like saying about Aidan that he committed the act of defamation by going to the police, reporting it to them, and then going outside and simply telling a few friends. He was not doing that. He was broadcasting. That example, I'm trying to come up with, it's probably not a good example. I'm trying my best here. I'm trying, Your Honor. I'm trying to quote the great Elaine Bredehoft from the Johnny Depp trial. It's a terrible analogy again because there was no attempt to change the law or to get an action moving. She was leaking it to congressmen because it made the perpetrator, the alleged perpetrator that she accused, look bad. And that is defamatory, especially when there is no proof, let's say, which I imagine in that case probably came out later that there was no proof that they've actually done it. Here we have ample proof that they were in some way, shape, or form responsible for the death of John O'Keefe. And that's because if Karen didn't hit him, somebody inside that house did. Who is it? That's a question that everyone wants the answer to.
Which wrongdoing is reported outside of governmental channels and not given petitioning protection. I want to talk about Attorney Pyle's comment about context, that it's important to consider context. They cite North American expositions for that principle. We cite it as well. The context that the court was considering in North American expositions wasn't the political climate. It wasn't the overall course of conduct. It wasn't, some atmospheric assessment of what was going on in the world. It was the context of the forum in which the statement was made. And there, the forum in which the statement was made was to the South Boston Community Foundation, which was created by the legislature, placed in the executive branch, and responsible for distributing public funds. And that was the context that North American expositions, which they cite, concluded was an appropriate forum in which petitioning activity occurs. Here, what they are encouraging you to do is say, Judge, consider the gestalt of what Mr. Kearney was involved in. Consider that he was in, as a general matter, using his YouTube page and his for-profit entity to talk about issues. That's the context in which you should find that his accusations against private citizens of murder were petitioning. No, that's not what the cases say. The cases say, the North American expositions in particular says, that when considering context, it is the forum in which the statements are being made. And I think that that's a crucial distinction. I do want to say one other thing in response to Attorney Pyle.
Just one?
I can wait as well, because I know you came out asking questions, and I don't know whether, Judge, at some point you want to, whether we should make more expansive remarks, but I'm happy also if you have something that you'd like to key in on to the whole. I wasn't quite, now I lost my train of thought. Oh, I think it had to do with intent and motive. It is absolutely true that the court should not consider Mr. Kearney's motive at this point. And yet, Mr. Kearney, in his memorandum, spends pages and pages and pages telling you that he was motivated by a sense of justice, that he was motivated to shed a spotlight on this criminal justice proceeding, that his motive was to spur others to action. None of that matters. Even if true, it doesn't matter. What matters is what he did. And whether there is objective indicia of his intent. So his
I'm starting to kind of get a picture of Chris Matty. Notice how he's forcing the argument. Like, Judge, you have to understand, it's important to note that in this particular context, his particular words, what he particularly did, you see a pattern throughout this whole hearing. It's the same pattern. It is usually the hallmark of someone who has the weakest argument. Because someone who's got a strong argument, like Mr. Pyle, he just gets up there. He's like, again, I keep repeating it, but like, you see how stark the contrast is in the way that they're arguing. It's all there. Everything is being given away, and that's expected.
best motives here, and the same with Mrs. Reed, don't matter. What matters is whether the record, with respect to the statements he made to our clients, presents objective indicia as to whether what he was doing was intended to reach the government. And here, what we say is that the objective indicia, the fact that he never actually reached out to the government, the fact that he declined an opportunity to do so, the fact that he encouraged his audience to use coded language to defame the plaintiffs. Coded language, meaning language that by its very nature would obscure the government from knowing what he was doing. The fact that he engaged in private confrontations suggests that there is an objective indicia that he was not looking to reach the government. That's what matters, not his after-the-fact self-comparison to Oliver Wendell Holmes. What matters is the objective indicia in the record as to what he did.
So don't worry, we'll get to it sometime. Thank you, Dr. Moran. So, Attorney Pyle, let's talk for a moment about public participation. When I read your filings, I just get the sense that there's a little bit of overreach. And it's supposed to go to any statement reasonably likely to encourage consideration or review of an issue, and the language goes on. But how is posting to social media or encouraging people to participate in a rolling rally at plaintiffs' homes the type of public participation contemplated by the statute?
There have been a number of anti-SLAPP cases that have turned on use of social media to inform and mobilize other people. I had the very first one. It involved the plan to build a racetrack in the Plain Ridge Casino, and the Superior Court there held for the first time that posting on Facebook is protected by the anti-SLAPP statute. Posting on social media is the way today in which people connect with each other. Aidan Kearney has done that to great success in getting people involved in these issues. Indeed, posting on social media and posting on the internet generally, I would point out, is what led your affiants Rita Lombardi and Paul Cristofaro to do things that are clearly public petition. Going to Canton Town Meeting, going to the State House. Mr. Kearney, by the way, this suggestion has been made, Mr. Kearney never petitioned the government on his own, but they allege in their amended complaint that he was there protesting at the Dedham Courthouse. He was also up at the State House protesting to get the Attorney General involved in all of this.
And you want to tell me that that was not petitioning the government? Maddie, come on. Let's just agree that you're wrong, because you know that you are.
He decided that his words, his direct police report from Aidan Kearney to the Canton police wouldn't have done anything. He wasn't a witness to this murder. He reasonably determined, the facts would show, that mobilizing thousands of people to protest against this unjust prosecution would be a way, potentially, to get the charges dismissed as he believed they should have been, by putting pressure on elected officials to do so.
Yep.
That is core protection.
Encouraging people to participate in a rolling rally.
The rolling rally, Your Honor, is very much participation and likely to lead to further public participation. That was a caravan of cars that started in a supermarket parking lot, went to various people's houses, didn't stay for too long, ended up with a protest in front of the Canton Police Department. That is I recognize that he's been indicted for that conduct, but nobody was. It was a peaceful protest in cars, and Mr. Kearney is vigorously fighting, of course, the criminal prosecution for witness intimidation that arises out of that. rolling rowdy. It was also heavily promoted online, such that people who weren't there could see, look, there's lots of other people who believe so strongly in this cause. They're willing to go out on a sunny day and participate in a public event. That is also reasonably likely to enlist further public participation by others in this cause. So it is part and parcel of the petitioning activity in the case, and it meets the statutory definitions. Also, he's been sued, once again, for statements accusing plaintiffs of murder, statements that were made in connection with the ongoing criminal case. There's not just one element of the anti-SLAPP definition we're relying on. We're also relying on the statements that, at least during the entire time of the Karen Reed prosecution, his statements were made in connection with the pending judicial proceeding and were intended to reach the government directly or indirectly.
Let me turn to a few questions relative to the Reed motions. First of all, whenever you start arguing, I don't need to have the party spend any time on the 12b6 part. I mean, I can review the four corners of the complaint or the other complaint, I guess whatever complaint I determine is the operative complaint, and I'll consider your written submissions. But let me start with the plaintiffs. Would you not have responded to the issues raised in the June 23rd amended motion to dismiss, or requested from the court more time to do so?
Your Honor, we do respond to the June 23rd motion to dismiss. It's our position that the opposition that we filed following service of both the June 18th and the June 23rd motions to dismiss address all of the issues raised in both of them. We didn't feel that we needed more time to respond. In fact, we thought that the appropriate course...
But you take the position that I shouldn't consider amending the second motion.
Well, we do. I mean, we think it was a violation of the rules for them to serve it out of time without permission from the court. We think that it didn't comply with 9C. We think there are a whole host of reasons why the court shouldn't consider it. But if the court were to consider it, our opposition, which was served after we received service of both that and the June 18th motion, apply to both.
You took the time to have an affidavit submitted, which included a copy of the June 18th motion to dismiss.
Yes, we did do that. I mean, I'm not sure I understand the suggestion.
Why did you do that if you responded to the June 23rd?
Well, Your Honor, we thought it was important to bring to the court's attention what we considered to be Ms. Reed's gamesmanship with the rules of procedure. So she serves on us a motion.
That's why.
Okay, this is the issue. Remember that Karen Reed filed her motion to dismiss the complaint. Hi, baby. My kitty is here. Her motion to dismiss, and then of the original complaint, and then it has come to their attention that actually they failed to respond to the amended complaint. So that was an oopsie. But it's not that big a deal. And of course, Chris Matty and Tewksbury and the rest of the team, they're all going to be very much upset with the fact that Karen Reed's team didn't respond instantly to the amended complaint. And as a result of that, now we're getting to finally talk about, we're done with the Aidan Kearney question for the time being. We might come back to it, or maybe some other questions may be raised about Aidan's case. But right now we're turning to the first issue with the Karen Reed situation, and that is whether or not there is any argument to be made that, well, should Karen Reed even get a chance to raise the anti-SLAPP issue with respect to the amended complaint, because it was filed like a week later, I understand, June 18th and 23rd, so 5 days, I suppose, later. And can Karen Reed even use that? Or is she SOL and JWF, as George Carlin would have said?
All right.
Yeah, that's why we did it.
So, Attorney Seligson, apparently the original motion to dismiss that was served addressed the plaintiff's original complaint, not the First Amendment complaint. Is that correct?
The original motion addresses the complaint, which is extended by an amendment.
Hang on. It would appear, from what I saw, that, and I'm happy to give you, because I did compare and contrast of your original motion.
Yes, Your Honor.
And the second one. But what it appeared is that maybe someone responded to the wrong complaint. I don't know. But after the issue was brought to the attention, your attention, or whoever in your office, you unilaterally filed an amended motion on June 23rd. When Attorney Mattei references 9A, I might have missed it in 9A, but I don't quite see how you get to do that.
Well, Your Honor, the June 23rd motion to dismiss simply corrects the caption. But Your Honor, if I may answer the question.
The rule doesn't allow it, does it? Does Rule 9A allow me to send a motion and then a few days later say, I changed my mind, here's another one?
Nothing was changed. We didn't change. No one changed their mind, Judge. What happened was there was an amended complaint which simply adds additional factual allegations. There's no new.
Well, why wouldn't you ask for permission? Why didn't you just do it?
Because we thought we could reasonably deal with counsel. That's why, Judge.
Yeah,
and I don't think there's any prejudice to them by getting a complaint.
There's prejudice to the process, and I just don't know. It just seems to me this decision such as that I don't know whether it's a showing of entitlement or arrogance. I don't know which.
It's neither, Judge. It's simply correcting a motion to dismiss a complaint that was subsequently amended that has absolutely no change substantively, no change in parties, counts, theories, or anything other than additional facts, which we address in reply. So it's a correction of the original motion. We reached out to counsel after they pointed it out to us, asked them.
They told you they weren't going to accept it.
Well,
so you decided, okay, I don't care what they say, we're just going to do it.
How are they prejudiced? We even offered them more time to respond to it. It's form over substance, Judge, with all due respect. The arguments are still presented. The theory that they're advancing is still addressed. There's no prejudice, there's no change except some number paragraphs, and where it said Plymouth, it had said Barnstable because this is where the case originally originated. So while I understand the mechanics of the process under 9A, we really haven't violated anything. We've responded to the amended complaint, which is purely an extension of the original complaint. There's cases that hold for that position. It's not an inoperative, superseded complaint. It's an extension of what was initially filed. And we've addressed the arguments.
It was filed as of right. So that's the operative complaint. The amended complaint was filed as of right.
But it still extends what was initially pled at the initiation of this lawsuit, which is a theory that has not changed by virtue of an amendment. What happens in the amendment is some additional factual allegations are included.
So why didn't you respond? Why didn't you address those in your June 23rd? For example,
we addressed in the reply, Your Honor.
Right, but you could have done it. You could have done it in the amended motion, couldn't you? Because the reply is not to argue stuff you might have missed. The reply is to talk about new stuff.
But we are under no obligation to address every single factual allegation.
You're not, but you're also you don't have the ability just to throw in a reply because you want to put in something you might have forgotten to address.
The purpose of a reply is to reply to the arguments that are in the opposition to the motion to dismiss, which is what we've done. And I'm here to argue it verbally as well. Let's
talk then for a moment about the reference to the statements that Ms. Reed made in 2024 to Mr. Muir.
Yes, sir.
And you address that in a reply. First of all, your reply uses the word allegedly in describing Ms. Reed's words. Do you not concede that she said those things?
Well, the alleged is behind what the purpose.
It says her alleged words. That's what your reply says.
Your Honor, I haven't seen the documentary, so I am responding and advocating for my client's argument. So I'm not going to admit that that's what she said until I've seen it. So for the purposes of argument, I must have used the word allegedly. But the arguments are that that is petitioning activity.
Let's take a look at paragraph 33.
But the complaint?
Yep. Then
Paragraph 33 of the amended complaint, Your Honor?
yes. And that's where the plaintiff's alleged Ms. Reed was the source of a blog post. And where she says Jen McCabe is a mastermind of the cover-up and Colin Albert had motive to kill Mr. O'Keefe. And I use that particular paragraph just as an example. My broader question is, how are Ms. Reed's statements to Mr. Kearney, not things in court filings, but her statements accusing the plaintiffs of murder, petitioning activity? Or put another way, let's...
Somebody else or others were. That's in connection with that judicial proceeding. That's protected petitioning activity. The complaint rests solely on that type of language. It's also...
In case you were wondering, that jump that just happened there, again, that's in the original. I didn't have any control over that, but we only missed like a couple of seconds, so you get the gist. The gist is, now the judge is asking about Karen Reed's allegations that Colin helped murder John O'Keefe and that Jennifer McCabe was the mastermind. How is that protected activity? How is that not defamation? And Seligson is arguing, well, that's also petitioning activity.
Knowing that Mr. Kearney obviously has a wider audience is arguably to enlist participation. So at least two statements of the anti-SLAPP statute would cover those statements. From day one, she's taken the position it wasn't her. She was prosecuted twice and acquitted.
Let's go back for a moment, if you could, to Ms. Reed's statements to Mr. Muir.
Yes, sir.
She suggests in your reply are within the scope of the anti-SLAPP statute. One of the categories being encouraging consideration and review, reasonably likely to enlist participation. So, in the criminal trial, the case went to the jury on June 25th, 2024, correct?
Yes.
Okay. 3 days before, on June 22nd, 2024, Ms. Reed gave an interview to Mr. Muir, correct?
Correct.
Let's look at paragraph 97, 98 of the amended complaint. And in there, Ms. Reed states, among other things, I know Brian Higgins had a role in helping kill him, helped him get him in the snow, and helped frame me. And then Mr. Muir asked Ms. Reed, you make such strong statements about I think Colin Albert killed him. I don't know how without getting sued, because I don't even know if you're gonna. And Ms. Reed responds, if Colin can prove I'm lying and this is thought defamatory, he can sue me. So my question
I was
is,
waiting for this. I was literally waiting for this moment because we know that it was going to be coming one way or the other. We knew that the judge is going to bring it up because that is the most, shall I say, juiciest statement in that entire ordeal. You know what I mean? It's like well, if you don't like it, sue me. Well, he did. If you can prove that he didn't do this, go ahead and sue me. All right, your wish is my command. You have been served. And of course, the judge is going to bring it up. Well, let's see what Seligson has to say to that. I can't wait to hear his answer.
How can statements by Ms. Reed outside of her criminal trial, 3 days before the case went to the jury, to your own words, documentary filmmakers, that apparently were not going to be released to the public at that time, be considered petitioning activity? Like it's almost the claims and statements to the filmmaker of petitioning activity appears to presume that Ms. Reed was either seeking to influence the jury or she knew there was going to be a hung jury. How could it possibly be petitioning activity?
Well, firstly, the criminal trial is still ongoing. The jury hasn't got the case yet. The jury hasn't decided, so the judicial proceeding is still ongoing. And if we actually look at what happened, there was a mistrial, which leads to...
For Mr. Muir to release those statements?
I'm sorry, Your Honor?
The intent was for Mr. Muir to release those statements prior to the jury?
Well, I don't know what the intent was with respect to when this documentary was going to be released.
Sure as hell wasn't going to be released in 3 days, was it?
Well, even if it's going to be released in the future, she ultimately is still in the process of being prosecuted. The trial hasn't ended. It's still under adjudication. It's still a proceeding. These are still statements. These are still protected petitioning speech, regardless of what Mr. Muir's intention was or when he was going to release his documentary. But ultimately, there's a mistrial, and she's tried again and has the same defense, and that leads to an actual acquittal. So this is also to enlist participation. This is also in connection with the judicial proceeding that's ongoing, and therefore falls squarely into the statute's definition.
If it's made 3 days during a pending criminal trial, made 3 days before the case is going to go to the jury, and how is it made to enlist public participation?
In the future, because there's, or at the time, it's still part of a judicial. If you take aside the public participation enlistment aspect of the statute, it's still in connection with the judicial proceeding. Whether or not the documentary was published that night, that morning, or 3 weeks from then, it's still in connection with the judicial proceeding. It's still petitioning activity.
Because even though the jury trial would have been ending, and let's say there would have been a verdict in 3 days, and then documentary comes out 3 months after that, it is still petitioning activity to petition the prosecution and the police for charging the correct people. I don't know why he's just not saying it. Maybe he got a little surprised by the judge's question, but the answer is right in front of him. And he's trying, and I think he's doing a decent job, but I think that's the answer.
The statute doesn't say when the judicial proceeding has to have concluded.
There we go.
It says in connection with the judicial proceeding. Taken to its logical conclusion, it might be that she's even been, hypothetically speaking, convicted, and she can still say those things and argue it's in the anti-SLAPP statute protection.
Yep.
Because it's in connection with the judicial proceeding.
I agree.
So plaintiff want to respond?
Yes, Your Honor, I do. What Ms. Reed's counsel has just suggested is that there is no limit. There need be no nexus between what she says and the likelihood or the plausibility that it will reach a governmental body. He just said that even post-conviction, and we actually have allegations that she made defamatory statements, both she and Mr. Kearney, post-verdict. But what they're saying is even post-verdict, because she in the past had been subject to a criminal prosecution, she is free to defame people no matter the audience. Just because she's commenting on somebody else's guilt, not her own, somebody else's guilt. Blakesley says exactly the opposite. Blakesley says that this court is required to assess if a plausible nexus exists, and in doing that, analyze the objective indicia of a party's intent to influence a government proceeding, such as the timing, audience, and content of the statement. That's exactly what you were just trying to do here. With respect to the murder allegations, The audience of Ms. Reed's statement to Ms. Murr is not the broader public. She's saying that in a closed private room to Ms. Murr and the small production staff around her. Now, if that statement is later published, she may be on the hook for additional damages. But the defamation that she articulates to Ms. Murr is not enlisting public participation in anything. It is a private statement to Ms. Murr and her small production staff.
That is insane, the argument that he is making. I can't believe the words are actually leaving his lips, that he has the audacity to try. It's not even creative. He is arguing that when Karen Reed made the statement in this small room to 5 people, the production team, that right there is defamation. But then when it would be broadcast, well, then it's another whole slew of defamation. None of that could possibly be eliciting public participation. Because what, they don't live in Massachusetts? Who gives a damn? Doesn't matter where they live. They could be in other countries because the whole world is watching this case. That's how bad it is, Maddie. And you're going to stand there and with a straight face, unapologetically argue that, well, she made the statement in a closed room to a production team. That's defamation. She defamed her. Just like that lady who filed a police report and then went out and spoke to Congress people and saying, leaking that information out, that was defamation. So is it here. But the two are so radically different. One is, it's a private report alleging SA and DV or whatever against one individual, and then leaking that to everybody before a full investigation can be conducted and the veracity of the statements can be made. And later it turns out that it's false, more than likely. And then she gets prosecuted, or not prosecuted, and then she gets sued for defamation and she's found to be liable. Versus a woman who's wrongfully prosecuted, gets acquitted, tries to bring justice to the real, to John O'Keefe by bringing the real killers to justice. And now the real killers are going, no, she can't say this about us because she has no proof and she's defaming us. Literally apples and oranges, the definition of apples and oranges. Wow, that's... at this point, I can't even call it creative. That's just stupid. I'm sorry, Chris Maddie. I thought you were better than this. I thought you were above board, but you're not.
As you point out, I think, or Rob pointed out, the idea that there was a plausible nexus between that statement and something that was under review by a judicial body is so far-fetched as to be totally unreasonable. That statement wasn't going to reach any judicial body. By the way, Karen Reed, if she wanted to reach a judicial body, had every opportunity to do that. Instead, she's talking to a documentarian in private and accusing all of my plaintiffs of murder. Period. There is no nexus to any judicial proceeding.
So why don't you go and also name as defendant the documentarian who published all of that? Why didn't you? He re-defamed your plaintiffs, right? By publishing it. Or is it not published yet? I don't know. I'm asking the question. Seriously, I don't know. And when it does get published, are you going to sue him too? For re-defaming, quote unquote, your plaintiffs? Wow. That's something else. That's creativity that goes beyond anything I've ever heard. In the realm of defamation law, this is brand new ground. He's trying to create new law. Good luck with that, Chris.
And this does get to the post-verdict statements that we allege she made and that Mr. Kearney has made up until last month. I can touch on that now because the issue of having to analyze whether there's a plausible nexus is one that's going to apply equally to those statements. And what Ms. Reed has argued is that her statements in, I believe, 2026 to the Rotten Mango podcast, in which she again defames our client post-verdict, well, she says, she argues, that has a plausible nexus to the O'Keefe family's civil case against me, and that by accusing these innocent people of murder, perhaps I can convince the O'Keefe family to drop their case against me. Now, the O'Keefe family isn't a governmental body. They're a private litigant. That's not petitioning activity. And Mr. Kearney equally has a lame excuse for his post-verdict statements, where he says, well, there's the statute of limitations for murder still exists. I can spout accusations of murder into the void, and there's some plausible, some governmental entity will pick that up and then prosecute these innocent people for murder. That is simply not plausible. It's not reasonable. It's an after-the-fact justification that has no support in any of the case law. Go ahead.
Attorney Seligson, do you want to respond?
Your Honor, the statements are still in connection with the judicial proceeding.
Okay. Attorney Pyle, I guess the characterization will excuse my warrant some response.
Thank you, Your Honor. And I'll note that.
And again, folks, I just have to apologize for the quality of the video. It has nothing to do with me. The video that we got, the individual who recorded the video had their live chat on screen, and they were adding as moderator every single person that was chatting, and then they were liking and commenting on every single super chat live, and that really lagged the video. So, but we're getting most of it, which is great. I wish we could have gotten it from some other source. Again, I get it. You got to do what you got to do, but when it corrupts the original file and there are no other sources to be able to extract the video, it's very frustrating for the content creator to not be able to get a clean copy. But and this is, I'm using the trial channel's rendition, so you know it's bad if we can't fix it. So, but we're almost done. We have about 15 minutes of argument, and I imagine there's probably going to be 20 or 25 more minutes of this video. But this is amazing stuff. This is just outstanding legal work and argument that we were all looking forward so much for, and now we finally get it.
The argument that was just made that post-verdict statements can't be petitioning was not connected to any element of the definition of petitioning in the anti-SLAPP statute. So I'll read one. Any statement reasonably likely would encourage consideration or review of an issue by an executive body. The Norfolk DA's office still exists. Karen Reed has been found not guilty. If Karen Reed's not guilty, somebody else is guilty. Aidan Kearney fervently believes that the plaintiffs are guilty. It is still possible for them to be charged. In fact, one of the allegedly defamatory statements that they identify in this case is a TV interview that he did, not one of his YouTube videos, but a stand-up TV interview right after the verdict. And Aidan Kearney said, "I would hope now that Karen Reed has been found not guilty, we can all unite and demand that the Alberts and the McCabes be charged with the killing of John O'Keefe, because they're the ones who did it." That is a demand on the government to bring charges. It is a statement also that is reasonably likely to bring about further public participation to demand that charges now be brought against the real killers. That is petitioning.
Okay,
it's glorious. You see how short, sweet, to the point. There's no magic. He's not trying to jump through hoops like Chris Maddy is, constantly like arguing and arguing and arguing and arguing. You ever heard the phrase, the one who has the shorter argument wins? This is literally the textbook example of that.
Give you the chance to argue your motions. What would you like to add?
Your Honor, what I'd like to add is, without regurgitating what we've already said about stage one of the Bristol asphalt framework, the sole crux of the complaint, the amended complaint, this lawsuit against my client, is solely based on statements that are petitioning activity protected and immunizing her under the anti-SLAPP statute. The second prong of the framework requires the burden to shift back to the plaintiffs to show that the statements are devoid of any factual support or any legal basis. We have put forward enough evidence. You referenced the affidavit and the transcript attached to my declaration affidavit. That's in there, and they cited to in our brief. But the facts that established at stage 2 of the framework, most importantly, my client was acquitted of the prosecution's charge that she was responsible for John O'Keefe. The case of Faber versus Walton, the holding was judgment in favor of a party to litigation is conclusive evidence that petitioning activity was not devoid of any reasonable factual or arguable basis in law.
Oh, that's very important. So when you win your case after stating certain things to the public, like the O'Keefes and the McCabes and Higgins are responsible for the murder, and then you get acquitted, that can be used as a basis. Your acquittal can be used as a basis that, well, clearly your arguments did not fall on deaf ears, and they worked. So you clearly did something right, and that can be used to vindicate you of the defamation. Interesting. That's very interesting.
She submitted an affidavit that she did not strike Mr. O'Keefe with her vehicle.
What's the nexus between the finding of the Norfolk Superior Court in a criminal case against one defendant to claims against these plaintiffs?
Because her petitioning speech has to be supported by facts. They have to disprove that there are facts to support her petitioning speech. So that fact is highly relevant. She didn't strike Mr. O'Keefe with her vehicle. The chief medical examiner, Dr. Irini Scoribello, testified that Mr. O'Keefe's injuries were not consistent with a vehicle strike, that they were consistent with a physical altercation. Mr. O'Keefe did not show signs of a physical altercation before Ms. Reed dropped him off at 34 Fairview Road in Canton. They did not have an altercation at the Albert's house. He suffered a wound on the back of his head, which was consistent with falling on a ridge surface. Present in the basement garage at 34 Fairview Road, Mr. O'Keefe had wounds on his arm, consistent with a dog bite. There was a German Shepherd in the home with a history of aggression. That's also testimony from the trial. Mr. O'Keefe's phone was at some point inside the Albert's home. That's testimony from Mr. Ian Whiffen. Ms. McCabe used her phone at 2:27 a.m. on January 29th to type in how long it takes for a person to die in a cold. That's the testimony of Richard Green from the trial. In the early morning hours of January 29th, 2022, Mr. O'Keefe's body was not present where it was later found. That's the testimony of the plow driver, Lucky Loffred. And then there's a testimony from Dr. Laposada, the former chief medical examiner for Rhode Island, and a professor at Brown University, who opined that Mr. O'Keefe died from a massive skull fracture that was inconsistent with a vehicle strike. Those are the facts that the plaintiffs now have to prove are somehow devoid. We're devoid of proof. So the statements of petitioning, they are covered by the anti-SLAPP statute. The amended complaint rests solely on those statements. And the support for her petitioning activity is factually supported by what I've just read and what I've submitted to the court attached to my affidavit. For those reasons, Your Honor, for those reasons, I ask that the court dismiss the lawsuit against my client and award her attorney's fees as is provided under the anti-SLAPP statute.
Thank you, Attorney Stumpf. Aidan, do you want to respond to Ms. Reed's arguments?
Just briefly, Your Honor. And before I do, I did just want to point out, in response to the court's question earlier to Attorney Pyle about whether posting to social media is by its very nature, petitioning activity. We cite the Sheehan case in our brief, which stands for exactly the opposite. I hesitate, Your Honor, to even engage with what I just heard, because I think it's prejudicial to my clients to even entertain what
Wait. Everything that Seligson said, so all of the evidence, the facts, and the testimony in the trial, that's too prejudicial. I don't even want to touch that because it really hurts my case, Your Honor. I can't even address it. I'm incapable. So instead, I'm going to strawman and I'm going to attack something completely different that Seligson didn't even say, and I'm going to answer a question that you asked earlier because I don't want to deal with that because I am going to get cooked if I have to respond to that because I got nothing. That's literally what he just said.
I believe it's just nonsensical recitation of evidence that doesn't implicate any of them in crimes that has been shown to be discredited. And I'll start by pointing out that he doesn't mention Colin Albert once. Doesn't mention him once. And the reason he doesn't mention him once is because he knows that the undisputed evidence, as we present in our brief, is that Colin Albert wasn't even there when Mr. O'Keefe arrived. And because he knows that the other evidence that they suggested implicated Colin Albert in some sort of altercation, that is that at some point he had scabbed knuckles, that they are in possession of photographs that show him before that and after Mr. O'Keefe's death with completely uninjured knuckles. So I only raise that to show just how frivolous these arguments are. With respect to Ms. McCabe, Attorney Seligson just said again here in open court that Ms. McCabe Googled how long to die and called at 2:27 a.m. That is not true. That was established to be definitively not true in the second trial. Ms. Reed did not allege it in the second trial. She didn't even call the discredited expert who Mr. Seligson just cited. It's the contrary. Celebrate officials.
Well, of course they're not going to call the expert witness who got creamed on cross-examination and called out because the search did happen and she deleted it. So they're like, well, we're not going to call the guy who's going to call her out again. He just admitted Seligson argument. This is nuts. This is crazy. I've never seen anything like this. Don't forget to like this video, comment below, and subscribe to the channel. Wow.
That software testified without contest that server showed up at 2:27 a.m. because a previously opened window was used to conduct the search after 6 in the morning. And that was a feature of the software and no evidence at all that the search happened at that time. And obviously, it's absurd to even suggest it because then there are two searches, I believe it's 623 and 624, that are miskeyed in exactly the same way.
How convenient.
As the prior search. It's just nonsense. And I think that the important thing is, as you point out, the fact that a jury was not able to reach a verdict as to the fact that a jury concluded that there was not sufficient evidence beyond a reasonable doubt to convict Ms. Reed of these crimes is not affirmative evidence that anybody else committed them, much less witnesses who have never been targets, never been subjects, testified in open court multiple times. It's just offensive to hear that type of argument here. Now, I don't think you're ever going to get...
Now, folks, I don't know if you're like me, but I'm starting to get a feeling that Chris doesn't believe his own words. His own words leaving his mouth, he doesn't believe in them. He's just regurgitating them because that's what he has to do for this case in order to try and win it. I don't think he believes the words that are coming out of his own mouth. Am I the only one? Let me know in the comments below if you think like me. And if you're still here, I mean, folks, we are well past the 2-hour mark, if my math is correct with respect to the video. I know there's going to be some editing, so maybe we're like approaching 2 hours. And if you're still here, God bless you, because this is a really long hearing, and especially with my commentary making it even longer. I am in awe, simply in awe, that you are still with me, so thank you.
To that stage of the analysis, because I think as we've shown, none of the allegations you've made against Mr. or Mr. Kearney in petitioning activity have shown it. I'm sorry?
None of them?
None of them. I mean, I think there is, as Mr. Pyle has suggested, Mr. Kearney separately, now I'm not acknowledging that this was petitioning or not, but Mr. Kearney has engaged in criticism of the Norfolk DA's office, the police department, and the police. None of that is at issue in this case. And yes, Your Honor, none of his accusations of our clients that they committed murder was petitioning activity. Not a single one. Not a single one. And there is no case to suggest that that sort of accusation against a private citizen, untethered to any effort to report to the government, is petitioning. None. And so the question I think that this case presents is whether or not this court is going to radically expand anti-SLAPP protections to include what historically has been considered defamation per se, and shut the courthouse doors to people like my clients who've come here seeking and invoking the court's protection to press their claims, or whether they will have no civil recourse, not just them, but any resident of Massachusetts who is falsely accused of a crime by another citizen.
Slippery slope argument. You're going to destroy and eviscerate defamation law if you do this, Judge. For everyone. Don't do this. It's almost like a threat.
Untethered to any petitioning activity, whether they will have civil remedies or not. And to me, the case law that we cite in our brief makes it clear that the narrow purpose for which the anti-SLAPP statute was enacted certainly does not extend to what historically has always been understood to be defamation per se, the worst type of defamation, the accusation of one citizen of another, a false accusation that they've committed a heinous crime of murder when that has not been tethered to any report, any petition, anything with respect to government.
Thank you, Mr. Nelson. Anything else?
No, Your Honor, I stand by my
Very Pyle.
Yes, Your Honor. The suggestion is repeatedly made that accusations of murder against private people are not protected by the anti-SLAPP law. That is not the law. And Mr. Maddy just said that those statements can't be protected by the, quote, very narrow purposes for which the anti-SLAPP statute was enacted. The Supreme Judicial Court in the Duracraft case noted that the language of the anti-SLAPP statute is, in fact, very broad. It broadly protects petitioning activity. Yes, even when it results in the dismissal of an otherwise meritorious defamation claim. It has long been the law, at least since McDonald versus Payton, which we've cited in our brief, that anti-SLAPP applies to defamation claims. It doesn't matter if it's defamation per se, which is one of the old common law characterizations of defamation, the commission of a crime, loathsome disease, or whether it's defamation per quad. It applies to defamation cases. These plaintiffs' defamation claim is based solely on Mr. Kearney's accusations that they committed murder, and those accusations were inextricably bound up in his protests against the prosecution of Karen Reed and the failure of the government to investigate the plaintiffs. The notion that there's no reasonable factual support for Mr. Kearney's petitioning activity is laughable, given the extensive evidence that you've heard about at the trial and that our brief explains in great detail. Mr. Maddy didn't say anything about the Ford Edge that Lucky Loughran saw parked in front of 34 Fairview. There's no explanation for that. The notion that he cannot make these statements, comment on a pending criminal case in order to get people involved in this matter is simply not accurate. The anti-SLAPP statute provides very broad protection for petitioning activity. And it doesn't require that anybody report anything to the government. It extends to the statements that are made that are intended indirectly or directly to reach the government. That concludes my argument on the anti-SLAPP motion. I did want to raise one other housekeeping matter with Your Honor in order so that the record can be clear. Back at the Rule 16 conference, Your Honor asked the plaintiffs to file a thumb drive containing all of the allegedly defamatory videos. We got it. You have received such a thumb drive? Oh, I didn't know that because I didn't receive a copy. I'm glad that that thumb drive is now in the record. I know there was a thumb drive attached to the anti-SLAPP motion that may have contained a few of the videos. I'm not sure if they...
right?
I don't think we noted that we received it, no.
Oh, okay, all right. They sent it in. They sent a thumb drive in with the links and all that.
Containing every allegedly defamatory video in the case? Okay. Thank you, Your Honor. That satisfies me on the issue. I would request a copy.
Happy to give you a copy. Your Honor, very briefly in response. The Durk case cited by counsel.
Well, cited by everyone.
Which
I cited it too, so.
Which I relied on in saying that the purposes of the anti-SLAPP statute are narrow, reads as follows. Section 59H is, quote, strong medicine, and used only in a limited context, requiring, quote, necessarily narrow and strict construction. That's what I was relying on when I made that observation to the court. And the last thing I'll say is, it is of course true that the anti-SLAPP statute applies to defamation. The point that we made, and I think the point that counsel doesn't even dispute, is that where the defamation involves accusation of a private citizen of murder, and that accusation is not made to a law enforcement agency or the government, that it has never been given petitioning protection.
Okay. Thank you all for your arguments. The matter will be taken under advisement. Can I speak with all counsel at the side of the bench, please?
After the brief sidebar, the hearing is dismissed, writes the trial channel. Whew. Thank you to all parties who participated in recording this. I just wish in the future, don't have anything on your screen as you're recording, otherwise you are creating lag, very serious lag, and everybody sounds like goats when the final version is released. We want your honor to believe that we have a good argument. It's like, it's so frustrating to have to sit there and listen to all of that. I hope you also enjoyed Zinnia's surprise appearance. She normally doesn't come down here when I record, but today for some reason she decided that she wanted to participate. Hi, baby. She's just walking around. You can't see her right now, but she's like patting herself against my feet. Hi, baby. And Gillian is sick. He's got like some sort of, he's got some sort of summer cold. I don't know what's going on with him, but yeah, he's been a little sick, the poor baby, the past few days. But it's just a summer cold. I think Zinnia had one last year, and they get better. I think they also call it like kennel cough. I think it's the same for cats and dogs, if I'm not mistaken. But yeah, you all wanted to see Zinnia, so now you finally get a chance to see her. There you go. The hearing. Oh my God, what a magnificent piece that we now have as part of history. This is probably one of the longest hearings that we've ever had to cover on this channel. It was about an hour and 10 minutes of pure argument, and plus my commentary, I think, carries us over the 2-hour mark at this point. But yeah, folks, it's petitioning activity. Karen Reed and Aidan Kearney have simply, through various mediums, social media like Facebook, YouTube, Aidan's website, and all of these other platforms that are at their disposal, like X, etc., have allowed them to disseminate information. It was all petitioning activity. And you can argue, Chris Matty, you can argue all you want that it's not, and try and get creative that it's not. But unfortunately, I don't think you're going to be successful when all is said and done. Precedent seems to be working against you. It seems to be unequivocally clear, and I'm hoping that that's what the judge is going to see. So obviously time will tell, and as always, folks, I hope you enjoyed this very lengthy presentation. Don't forget to like this video, comment below, subscribe to the channel, say hi to Zinnia. She's so fascinated by the screen. She's looking at the screen right now on my laptop. Anyway, thank you all for watching. Thank you all for joining. Zinnia and I love every single one of you, and we will both see you in the next video. Bye, everybody.